That's when people start coming. Right. All right, looks like all systems are go. And I think we're ready.
Judge Newmark.
Oh, yes. Hello. Who's that?
Hi, this is Samantha Jervik.
Oh, yeah.
I
Oh,
believe,
yeah. I
yeah.
see that. Sorry. I had that in my mind there. I had to type that in. Okay. There we go. All right. Let's get on the record. Welcome, everyone. This is docket 4220 ER 103, the application of Northern States Power Company, Wisconsin for approval of its 2025 fuel cost plan. My name is Michael Newmark, the Administrative Law Judge for the PSC. We're connected on Zoom with the utility and commission staff in attendance. We've made this hearing both a public and party session. So we're here to also here to receive evidence from the applicant and commission staff, as well as comments from members of the public. Just looking at our Zoom participant list here, I do not see any members of the public in attendance at this time. So I just wanted to remind people who may be listening or will watch the live stream or the recording that will be on the YouTube channel that we will accept written public comments up until Friday, October 25th. They can be filed either on the commission's website through the public comments webpage or mailed to us by U.S. mail. We just need to receive those comments by the deadline, and then I'll review those and enter those into the record. I don't have a tally of the number of comments we have so far. I doubt it's very large, maybe close to zero, if not zero. But we'll still remain, there's still time remaining to accept those comments. So seeing that there's no members of the public in attendance, we're going to switch to the party session. If someone does join us before we adjourn, I'll poll that person to make sure they don't want to make a comment. So let's move on to the party session and get appearances. From our service list, we have, oh, hang on. Dave is joining us. Let's see. Off the record, we'll see if that's a member of the public. So Dave, I see you just joined the Zoom hearing for Northern States Power Company. There's an opportunity for the public to comment. So I'm not sure if you're affiliated with the utility or commission staff, but if you are a member of the public, let me know. You can make a comment at this time. No, okay. Must have been a mistake. Okay, that person dropped off. We scared him away. Just I didn't say it was the Public Service Commission. That would definitely scare him away. All right, so let's get back to the party hearing session with appearances, starting with the applicant.
Good morning, Judge. For Northern States Power Company, Wisconsin, Jordan Hamaiden from Michael Besson Friedrich.
All right, thanks very much. And Public Service Commission.
Good morning, Kara Kuntz, Assistant General Counsel, appearing on behalf of the Public Service Commission of Wisconsin.
Okay, great. Well, thanks everyone for joining us. This looks like it'll be a pretty brief hearing, seeing that there was no cross for witnesses. We may still see some additional testimony on the stand, but we'll see if that occurs. At this point, I'm going to switch our screen view to the offered evidence list. Bear with me for a second here. And I'm just going to start off asking our initial question. Is there any errors or omissions on the list in terms of the identifying the documents we'll be receiving for the record? So we can start with
the applicant didn't notice any, Judge.
Okay. All right, great, thanks. And commission staff?
We don't have any. Thank you.
Okay, great. So then we'll move on to questions about the comments that I have on the list. Just something I saw just recently that we did receive that looked like it was a late or in terms of timing, the the data request response was filed after the commission filed its exhibit for data request responses. I think it would be useful to have that updated so that we have all the data request responses put together on that exhibit. So that was just one comment I had. And a public comment exhibit, we'll file that if there's more than 5 comments. Otherwise, they'll just appear at the bottom of the received evidence list. I did have just to indicate that exhibit field 2 will be the staff update that witness field mentioned in testimony. There's also something that's a bit more complicated. So let me just first ask if there are any questions about those comments that we just talked about, just reviewed.
Yes, Your Honor, I do.
Yeah. Okay, go ahead.
So the additional links for PSCW AJF 7.4, could you refer me to which those are?
Okay. Well, I think it's just so if you look at the current exhibit, the data request exhibit, it's got, the links to the responses.
Mm-hmm.
Right. So it'd be like the public reply, confidential reply. And I think the one it's missing on the existing document. So it's this AJF 7.3. I think it was just that the response didn't come in, but it's been referenced in testimony now. It's I can't remember, it's the wind farm PPA. So we just need the new version. We just have the links to the public and the confidential version of that data request. Is that?
Yeah, I'm not sure that was a data request response.
Oh, okay. Well, let's see what.
I'm
Okay, well, let's go off the record. So, I mean, there's what's referenced here, the AJF data request. Was that verbally submitted then? I just want to close the circle on that blank spot is basically
right on these, and it says CPSCW AJF 7.3.
Right, but there's no link to it.
Yeah, 7.1 was the itemized list of modeling updates that were made.
Oh, okay.
And those were actually responded to as 7.3. I don't believe there was a specific data request response.
Mm-hmm. Okay, I see. All right.
That referenced the number 7.1.
Okay. Okay, then that's just my confusion there. So there was a new response that was related to a wind farm contract, wasn't there? I thought that had come up in the back and forth of testimony, but maybe I'm. So I guess the point being, oh yeah, so it's I think it's this one, this AJF 7.2A. Where's the footnote for that? So okay. So the updated response to data request S4 in this proceeding. So is that reflected in the data request?
In the DRR exhibit?
Right.
Yeah, that would be 7.2A. And it was specifically S4.
Okay. So it's this first line. I don't know if you can see it on.
Yes, that's correct. That's what that was referring to.
Okay. That's fine. Yeah, okay. I just saw because it was an update and I saw the blank spot. I thought maybe we were just waiting to fill in that spot. That's just my confusion.
I believe that there may have been a Delva exhibit that was filed that showed some information regarding the pricing of the wind farm
Yeah.
of a couple of PPAs. One was for a wind farm.
Yeah. Yeah, I saw that. Yeah, that's I think Delva 2. Okay, and then so that's fine. I just we don't need to do anything on the DRR exhibit. Seems like that's fine.
Okay.
But I wanted to
So
mention for field 1, so we have so people reviewed that comment. Just what we've been doing in the other fuel cost plan cases, there's 3 schedules on the staff exhibit, and I spoke with at least with Klaus Mailata from the fuel team, said that it would be okay, that staff would be able to conform all of those that exhibit 1 in all 3 fuel cost plan cases, so they appeared similarly, and that there's a Schedule 1, which looks like the one that was filed in 4220 ER 102. So, and I can show you that. But is that something we can expect an update to?
yeah, I'm familiar with that. I think back when this was being drafted, that was originally part of the draft, and based on NSP's confidentiality concerns, the fuel team had decided just not to include that schedule.
Yeah, I can show you.
In the past, we've been a little inconsistent with that schedule. The WEC utilities, we didn't include it.
Right.
MG&E, WPL, and NSP, we did include it. And I think in future years, we may just not include it in future years at all. But for this year, yeah, I sort of see what you say. WPL has it as a redacted version, and MG&E might as well.
Right.
And the WEC utilities did not, and as of now, NSP does not. So it's a question of what we need to do here.
Yeah. So I spoke with Klaus, and I would like to have you guys include the Schedule 1. I think it's important information that just puts context into the case, and it's good for the commission to have just to get that snapshot of the adjustments. So this is the one that was filed in 102. So I think if we could include those 3 schedules from now on, I think because and just to keep all the cases consistent, and I missed the ones in WEPCO and Pub Service. Unfortunately, I did not notice the difference there. But so this Schedule 1, because the staff did, in this case, approve the confidentiality request of the applicant. So the Schedule 1 in this case, you should just file a confidential version and a public version of this Field 1 exhibit, so that you redact the numbers from Schedule 1 from the public version. That's what I'm gonna hope we can do that consistently through at least the 3 standalone fuel cost plan cases in this year, and then we can continue that practice so long as staff does agree that this information is truly confidential, meets the standard of confidentiality claimed by the applicant. So that's going to be your first step of looking at how to evaluate whether to make a confidential schedule or not. But once staff does agree that this information is confidential, then you want to include it, but put it in a confidential version. So is that
okay?
Any questions there? Yeah.
Yep. So this would be filed as a revised with the R designation.
Because you didn't file a confidential version yet, you can just use C and P just alone without any R. That'll separate it from the original by having the C and the P on there. Okay. So that was off the record. So let's just get on the record. So we just discussed some adjustments to the exhibit PSC Field 1. We're going to conform it to other Schedule 1s, staff exhibit 1s from the other fuel cost plan cases. at least the ones in this year for Power and Light and MG&E. So that there'll be a Schedule 1 inserted into this exhibit. It'll contain the information similar to what was presented and received in docket 4220 ER 102, except that the Schedule 1 will be redacted in the public version, and there'll be both a confidential and a public version file. So,
okay.
Yeah.
And the Exhibit 2, is that referring to the standard delayed fuel exhibit?
Yeah, just
Okay.
a placeholder for that. Yeah.
And the public comments exhibit is only necessary if we get 5.
Yeah.
Okay.
Yeah, that's right. Okay. So I did want to just discuss very briefly Exhibit Delva 1, because I know that staff did accept the applicant's confidentiality request. I don't want to revisit that, except to note, first of all, to thank the utility, because I think that in a other recent case, I think it was 4220 CE 183, I had some issues with the applicant's confidentiality request, and just in terms of providing a rationale, which is displayed here. So what I have on the screen share here is the confidentiality request for Delva 1, and item 5 on that request form does ask for basically the reason why the request, the information being requested for confidentiality status meets the standards that the applicant's claiming. And I do appreciate getting more of a detailed answer for 5. So I think it just raised a couple issues in that last case, the 183 case, in that there wasn't really enough information, but at least this provides us with in writing a basis we can search back to and understand, and just to keep things consistent across the years, and in order to have us know what the basis was when the decision was made to accept the confidentiality request. So I appreciate that. I guess I'm just curious. I think the information, I'm not going to display it, but it does appear to me to be more aggregated and generalized. So it doesn't go through costs per month, and for example, it doesn't drill into a lot of the details that you may raise more issues in terms of competitive value. So I just wanted to I want to just put that out there, that in terms of looking at sort of aggregate data or data that may be for a whole year, to what extent that really does create a competitive disadvantage if it was made available to the public. I'm not an expert in that, but it seems like you'd probably need more information to get something to make it this sensitive for creating anti-competitive activity. But if Witness Delva wants to comment on that, it would be useful for my understanding and for the commission's understanding. But I just wanted to raise that as being, when you're looking at more generalized data, it may not trigger the upon some more enhanced scrutiny of the request. I'm not sure if it really triggered the confidentiality standards. But like I said, I'm not here to change the decision at this point. We're just too far along in the case to do that, and we can let it go. So I'll leave it up to the utility if it wants to comment on that or not. Probably through the witness, probably the best way to do that. So anyway, we can move on then, unless there's anything I want to hear from the utility. Okay, so get the list back up here. So it looked like we didn't have cross for witnesses as of yesterday. Are there any witnesses that the applicant or staff wish to have verified their testimony by affidavit?
Not for the applicant, but before we move off of the offered evidence, Judge, I just wanted to address the note on the bottom.
Yeah.
And
Sure.
We got busy this morning and looked through and indeed found what you were talking about, particularly with respect to references to a decision of the commission. There were a couple of spots, two in particular on Ms. Delva's testimony that you had identified, well, on those pages, which don't necessarily refer to decisions, but just to the practices that were used in that docket by the applicant and staff. And so, just to make sure that there's a good record on that. So in those instances, we wouldn't intend to provide an IRF number or anything like that. But certainly in 2 out of the 4 or 3 out of the 5 instances that you identified, we will do the refiling as directed.
Okay, great. Yeah, just do your best efforts. It's something that is explained in the facilitating matters order. So parties and staff do have a heads up about that ahead of time. But if you're raising or asserting that something was decided by the commission, we just want to see the citation, and we can relate back to the actual document. That would be useful for consistency and just record keeping practices. So yeah, I appreciate going through that again. I understand it may not be perfect, but especially if we can get at least one reference to the final decision in someone's testimony, then we at least know it provides that context. We can just relate back to that order if we need to dig into that assertion. We'll know which document you're speaking about. So
understood. Thank you.
Judge Newmark, I do have a question for Annie Delva. It's based on the SIR rebuttal, which was filed after I sent the pre-hearing notification saying we didn't have.
Yeah, sure, that's fine.
At the appropriate time.
Yeah, that's fine. Yeah, it doesn't looks like everyone's here and ready to go. So we can do it then. Okay, is that it before we get started? All right, so why don't we take our first witness? I'll have the applicant call your first witness.
Thank you, Judge. Our first witness for the applicant will be Ms. Julie McCray.
All right. See you there. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, go ahead.
Good morning, Ms. McCray. I'm Jordan Hamiden, counsel for Northern States Power Company, Wisconsin. Please state your name for the record.
Julie McCray.
Did you prepare and cause to be filed written direct testimony and rebuttal testimony in this proceeding, together with 3 exhibits marked Exhibit NSPW McCray 1, 2, and 3?
Yes, I did.
And each of those documents were filed at the commission. Strike that. Is all the information contained in those documents true and correct to the best of your knowledge?
Yes, it is.
Judge, I request that all the written testimony and exhibits I've just asked this witness about, and which are all contained on the offered evidence list, be admitted into the record of this proceeding.
All right. Yes, it is. Go ahead.
Thank you. I have no further questions for Ms. McCray.
Okay, and the witness is available for cross. Any questions?
I do not have any questions.
All right, thanks. Okay, thanks very much. You're excused. Next witness.
The applicant's next witness is Annie Delva.
All right, see you there. Raise your right hand. Do you swear or affirm tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Good morning, Ms. Delva. I'm Jordan Hamiden, counsel for Northern States Power Company, Wisconsin. Please state your name for the record.
Annie Delva.
Did you prepare and cause to be filed written direct testimony in this proceeding, rebuttal testimony, and SIR rebuttal testimony in this proceeding, together with 2 exhibits marked Exhibit NSPW Delva 1 and 2?
Yes, I did.
And each of those documents were filed at the commission in both public and confidential form?
Yes.
Is all of the information contained in the documents I just mentioned true and correct to the best of your knowledge?
Yes, it is.
Judge, I request that all the written testimony and exhibits I've just asked this witness about, and which are all contained on the offered evidence list, be admitted into the record of this proceeding.
Okay, so since there was no opportunity to file any motions on certiorari rebuttal yet, I'm just going to ask if staff has any objections to certiorari rebuttal.
No objections, just.
Okay. And Delva too, I guess, came in with certiorari rebuttal. Is that right?
No,
Oh, no, it's not true. That's fine. Well, anyway, it doesn't matter because I'm letting them all in, so it's fine. I just wanted to make sure since we didn't have time to, there wasn't the opportunity to file any motions regarding certiorari. I wanted to make sure staff didn't have anything to say about it. So that's fine. They're all in. No worries. Anything else for this witness from the applicant?
No, Judge.
Okay. And looks like staff had a few questions, so go ahead.
Yes, I do have a question for Ms. Delva. Ms. Delva, this is regarding your certiorari rebuttal that was filed yesterday.
Just introduce yourself to the witness.
Kara Kuntz, Assistant General Counsel for the Commission.
Okay, thanks.
On page 3, line 4 of your certiorari rebuttal, it states, and if you need a second to go there, it states that the company has overcollected by a specific amount, which is confidential. I don't have, scroll down. Yep, right there. Could you clarify whether this number is over a 9-month period or an annualized value?
This is over a 9-month period.
Okay, thank you. No further questions.
Okay. Any redirect? No redirect?
Nope,
Okay.
no redirect. Thank you.
All right. Thanks very much, then. You're excused.
Thank you.
Okay, we'll take commission staff witnesses.
I'd like to call Andrew Field first.
All right. See you there. Raise your right hand. You swear or affirm, tell the truth, the whole truth, and nothing but the truth.
I do.
All right. Go ahead.
Okay. Good morning, Mr. Field. Kara Kuntz for the commission. Please state your name for the record.
Andrew J. Field.
And what is your position at the Public Service Commission of Wisconsin?
I am a public utility auditor.
Did you file or cause to be filed written, direct, and rebuttal testimony in this docket together with the exhibit marked exhibit PSC Field 1?
Yes, I did.
Are the statements and representation of the testimony and exhibit you filed in this case true and correct?
Yes, with one correction.
Okay. Would you like to explain the modification, the clarification to your testimony?
Yes, the correction is in my direct on page 4. And it's further down the page. It is on line 16 and 17. So the reference to where it says the commission approved the use of a 24-month period due to significantly lower natural gas prices, the portion of that regarding the lower natural gas prices is an error. That was not actually in the final decision. I believe the issue was discussed in the testimony of that docket, but that explicit statement or mention was not in the final decision itself, which is what was referenced here. So I just wanted to make that correction.
Okay. That's interesting. Wait, I don't know how so you're suggesting to strike the citation to the final decision, the footnote 2? just clarify?
Well, my intent was to clarify that the portion about significantly lower natural gas prices did not come from the final decision.
Okay.
The portion about the 24-month period being approved, that was in the final decision. That is correct.
Okay.
Your
The
Honor,
final decision itself did not clarify a reason for it, though.
I understand. Yeah.
Your Honor, if I might make a suggestion, it would be
go ahead.
put a period after the words 24-month period. And then eliminate the rest of that sentence. You keep the footnote.
Yeah, I think so what do you think about that, Attorney Koontz? I think that would more accurately reflect the decision the commission made. I guess, Witness Field, I can't recall if were you on the case, the 126 docket? Did you have personal experience with that, or?
There was some testimony where this issue came up, but I was not. It was not my testimony. I reviewed it as part of this docket, and it was in my head, so that's how it ended up here.
Yeah, that's fine. Any thoughts, Attorney Koontz?
Could I have a minute just to talk with Andrew?
Well, not, I don't think we could do that at this point.
Okay.
Yeah.
Okay, so the suggestion was to put a period after
and then strike the rest of the sentence. So I guess, I think the nuance here is, the order does not reflect the lower natural gas prices as the reason, but I think what I'm hearing the witness saying is if you went back to testimony, you'd see at least there was discussion about lower natural gas prices being the reason. And I suppose the problem is, can we assert that was the reason if the commission didn't explicitly state that? And I think there's probably, I think there's probably more basis for eliminating that reference to lower natural gas prices in reference to the final decision than there is leaving it in.
Okay.
I don't know if possibly Witness Field could explain, based on his knowledge of 4220 UR 126, what the context of the case was. But I think in terms of what the commission approved, we probably cannot relate it back to as the reason being that for that use of 24-month period being the lower natural gas prices. But
yeah, I think we can accept that suggestion, just to put the period and then delete the rest, which will also remove the footnote.
Well, I think the footnote's valid because you are basing the commission's approval was you'd want to reference the final decision when you're talking about a commission approving something. So that would be
okay. So just the period and then remove the last part.
Yeah. Of this. So I think I wouldn't be, and we'll have the applicant here as well to review this, but I wouldn't be opposed to having Witness Field explain his knowledge of why he believes the commission approved the use of a 24-month period, but I just don't think it can be tied to the order and the authority of the commission having not explicitly made that decision. So, so this is good. I'm glad we decided this now. So we've had a number of cases in the recent past where I've had some testimony stricken from the written filings. and you'll need to refile to reflect the order to strike. But I made a mistake, and our records management people quickly corrected me because what I had the applicant in that case do was to black out the text that was stricken, so it appears, or people could read it as being that's a public redaction of confidential information. If you don't know the history and the context of the situation, that the redaction is based on a motion to strike or an order to strike. So on their suggestion, what we should be doing instead is just deleting the text, but leaving the spacing the same, so that you would just see a blank section when you're looking at the words that were being stricken. And then it may not, you probably fit it in there, but if you just want to put in brackets in the spot that's being stricken, if you put in brackets stricken by ALJ order instead of using the black line that just blacks out the text. So it just appears, so you just want to delete the text that's being stricken and replace in that space in brackets stricken by ALJ order, but keep the spacing the same as best you can, so that the next sentence would start roughly where it starts now, where it appears to be starting now. Does that make sense? Okay. All right. So anyway, continue with your questions for this witness, Attorney Kuntz.
Thank you. Mr. Field, have you had an opportunity to review the SIRSA rebuttal submitted by Annie Delva from NSPW filed on October 22nd, 2024?
Yes, I have.
Okay, I have a couple of questions for you. Do you, on page 2, line 1 of her SIRSA rebuttal, there's a table, which says Table 1 MISO charges. And it states there's on the third line, staff's audit position 12 months, and then below that, staff's rebuttal position 24 months. Do you have any comments regarding those two lines?
Yes, I just wanted to clarify staff's position, that in staff's direct, staff's proposal was to use the 12-month period. In staff's rebuttal, a 24-month period was discussed as an alternative for the commission to consider, but the period that staff proposes to use did not change in the rebuttal. So staff's proposed position is still the 12 months. The 24 months was merely an additional alternative that was introduced for consideration.
Thank you. And I have one more question regarding the SIRSA rebuttal. So this is also on page 2, lines 4 through 6, so kind of right under the table. There is a statement which says that the actual costs for September 2024 are the highest that have been observed since August 2022. It then goes on to state that this is beyond the period proposed by either staff's 12 or 24-month proposal, but encompassed by the company's 30-month proposal. Could you clarify whether the September 2024 would be included in the review period in staff's 12 or 24-month proposal?
Yes, it would be. As I noted in my rebuttal testimony and direct testimony, once the final update that goes into the delayed exhibit happens, we anticipate September 2024 to be the most recent month available, so that would be included in the final update for either the 12 or the 24-month period.
Okay, thank you. No further questions. Your Honor, the witness is available for cross-examination.
Okay, any questions?
You know what I would like to do, if it's acceptable, is to take just a few minutes with the client to see whether we have any questions on that, on the basis of what Mr. Field just testified to, or whether it would be more appropriate for us to rebut in some fashion. And I'm asking for just 5 minutes.
Okay, yeah, why don't we can take a brief recess. I think I did want to just give the witness an opportunity to, because we did strike that line regarding the statement about commission, the reasons why the commission approved the use of a 24-month period. And I did say that I would allow the witness to comment on the witness's understanding of the reason. I don't know if the witness would want to add to that testimony now.
Before the witness would address that, Your Honor, respectfully, I'm concerned that unless that testimony is based on firsthand knowledge, I'm worried that his suppositions or speculations about why the commission decided as it did would not be useful to the record in this proceeding. It could be prejudicial.
Okay. Well, I know that witness Field did participate in that docket. However, yeah, I guess our typical practice would have been to have the testimony that would have backed up the rationale, or at least the existence of this debate in testimony could have been filed before as an exhibit. However, this is coming in fairly late in the game in terms of looking at changing testimony, something that wasn't present at the beginning of the process. I think, why don't we attempt to ask questions first of the witness to see if we have foundation for the witness to make in terms of the witness's expert opinion and experience in the case of the 126 case, if he can comment on what he believes was the rationale for the 24-month period. So I don't know if you wanted to handle those questions, Attorney Koontz.
Mr. Field, do you have any comments to add based on what Judge Newmark asked?
I had no firsthand knowledge in 4220 UR 126 of this particular issue.
Okay, well, we can leave it at that. I think that's fine. Yeah, this was a little bit of wordsmithing in the testimony, so it was hard to, I think it's fair to say that was a nuance that, having it come up late in the game, it's not surprising that it was a pretty nuanced statement. So I think at this point, without more basis to dive into the issue further, we'll leave it at that. But yeah, that's just an unfortunate situation with timing and the wording of the original testimony. So I think in the future we could just note that for clarity on the record to maybe provide a clearer picture, or have the the backup documents offered as evidence in the when the rounds of testimony are coming into play. I think that as a statement on direct, then that statement, I don't know if the company had challenged that point in rebuttal, that the commission didn't make the conclusion that the lower gas prices was the reason to use a 24-month period. But at this point, I think it's just too late to really get to the answer in terms of the process. So we can just leave it like that. All right, so let's take a 5-minute recess and we'll.
I'm sorry to interrupt, Judge. I don't think that'll be necessary.
Okay.
We communicated on the side here and determined that
Okay.
no cross-examination or further oral testimony from any NSPW witnesses necessary. Thank you for indulging me on that request.
That's fine. All right, so do we have redirect? Did I ask for redirect on a witness field? I don't think I did yet. But there's no cross, so we don't need to do that either. All right, so at this point, I think we have everything we need from witness field, so you're excused.
Thank you.
And we can take the next witness.
The commission would like to call Samantha Jervik.
Okay, there you are. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, and nothing but the truth.
I do.
All right, go ahead.
Good morning, Ms. Jervik. Please state your name for the record.
Samantha Jervik.
What is your position at the Public Service Commission of Wisconsin?
I'm a public utility rates analyst.
Did you file or cause to be filed written direct testimony in this docket together with the exhibit marked Exhibit PSC Jervik 1?
I did.
Are the statements and representations in the testimony and exhibit you filed in this case true and correct?
They are.
Do you have any additions or modifications to your testimony at this time?
I don't.
Your Honor, the witness is available for cross-examination.
Okay, any questions?
No, Your Honor.
All right. That's fine then. You're excused. Thanks very much. So in terms of remaining activities today, I'm just checking our participant list, and no one else has joined us, so no members of the public for comments. I believe we do have a post-hearing schedule already in place, so I think there's one brief that can be filed by the utility. Otherwise, I don't know if we have anything else to discuss before we adjourn. Anything from applicant?
No, Your Honor.
No? And commission staff?
No, Your Honor.
All right. So just expect refilings in 3 working days, according to discussion here and what's appeared on the offered evidence list. Let me just add, I just want to state just generally that the documents that appear on the offered evidence list have been received for the record, and they've been verified by the witnesses. So thanks everyone for joining us and participating today. And if there's nothing else, we're adjourned. Thanks very much.
Thank you.
Thank you. Bye.